नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां आज हम आपके लिए लेकर आए हैं एक नया लेसन।
Again, you've all read and reread the original judgment on Government of NCT Delhi. For those of you, what is it that we're looking at? We are trying to find out the aid and advice feature. We've already seen that the aid and advice feature is not symmetrical vis-a-vis president and governor. Why is it not symmetric? Because the president is always aided and advised by the prime minister, except when he is appointing the prime minister at the start of a new parliament. Article 75. President also has unwritten implicit two areas of discretion, which paragraph 174 of Shamsher Singh told us. Justice Krishna Iyer says, apart from section article 75, where the president on his own discretion appoints a person as prime minister, he also has a discretion to dismiss an assembly that refuses to resign after he lost the confidence of the house. And number two, to dismiss a government which, even though having the confidence of the house, is actually doing unconstitutional things. That is, if there's a sort of a defense of the constitution, requires the president then to dismiss this ministry. Other than that, in all other areas, we have a system of collective responsibility. And what is collective responsibility? That is, the executive under Article 75 is collectively responsible to the parliament. So therefore, it has three elements to it, as Justice Chandrachud tells us in his judgment very nicely. He says there is a confidence principle, which is that you must have the confidence of the house. That's one element of collective responsibility. Confidence principle. You must have the confidence. How do I measure the confidence? Through a vote of confidence or through a vote of no confidence. Okay? That's how you understand whether a government is accountable and has the confidence of the house, through the test of voting of confidence. But it also has inbuilt in it, he tells us, a unanimity principle. That is, unanimously, the entire Council of Ministers operates on a unanimous principle. They all work together as one team with the Prime Minister at the head to pull. This is not a case of a wartime ministry where you can have differences. No. In collective responsibility, once the cabinet has taken a decision, everybody is bound by it. It has that element of a democracy. You can speak before the vote, but having voted, it becomes the unanimous view of the entire. And the third is what is known as the confidential principle. Confidential principle, different from confidence principle. Okay, this is confidential principle. That is, the discussion that takes place in the cabinet before a final decision is taken will not be shared with the house. So you come as one single voice to speak in the house, or the minister comes and speaks after taking permission of the cabinet, but you cannot speak with, you cannot explain to other people the differences of opinion that took place inside, having once taken it. So the unanimity principle, the confidence, all this is a feature of parliamentary democracy. And we notice that the president is in all matters aided and advised, except for those few matters where he is not bound by the discretion of the Union Council of Ministers. Next, we came to Article 163. That was Article 74. Then we discussed Article 163 last week, where the Constitution itself says that aid and advice does not cover the full scope of governor's functions. There is, under the Constitution, explicitly given some areas over which the governor acts in his discretion, and therefore explicitly there he is not bound by aid and advice. So we looked at that listing 371, 356. I'm not repeating it. We've done it a couple of times in the past. Yet, there can be additional categories. Just like in Shamsher Singh's judgment, the Supreme Court came up with 3 non-exhaustive categories, even though the Article 74 has nothing similar to 163. It appears as if everything the President does is on aid and advice, yet using and section Article 75 and 103, the Supreme Court came up with some categories where he is Madhya Pradesh Special Police Establishment case, where if a chief minister or a minister prosecution permission is sought and the cabinet says no, ye sab bahut achhe hain, there's no need to prosecute, the governor will examine it and then come to his independent discretion of his own and decide whether permission should be given for action under section 197 CRS. Now when I come to union territories, okay, you will find that the nature of aid and advice is of course the same. That is, what is the kind of aid and advice? But the area over which such aid and advice is given is different for UPs compared to states and as compared to president. It's in that sense that I say the aid and advice is not symmetrical. However, the nature of the aid and advice is similar. If you give aid and advice, you will be bound to follow it. But when it comes to union territories, it is slightly different. Okay, Mitansh, you asked that question, so let me quickly deal with it before I come back to union territories. The doctrine of necessity is a doctrine which basically says, even if there is no legal provision available to you, like in that particular case, the granting of permission for prosecution of a chief minister under Prevention of Corruption Act is not one of the explicit grounds where the governor has been given discretion under the constitution, because those are listed in Shamsher Singh's case. Yet, doctrine of necessity says if circumstances require, you can legally be provided with a remedy because the grounds are something that have not been conceived of earlier by the draftsperson, but the condition is so serious and therefore the survival of the system. So the test for necessity is, it's not just a women fancy. It has to be exercised because the survival of the human being or the survival of the system requires it. So if I can just give you an example, in first year you studied the Spelunkian explorers case in Jurisprudence 1. You remember? Those people who got lost. Did you study that? In Jurisprudence 1, did you study Spelunkian explorers case, please? Explorer's case, this is actually based on a real case, as you know, and when they were locked in a cage, and for survival they had actually killed one of their fellow people and eaten them up. And in fact, whether they should be convicted or not, one of the main defense was doctrine of necessity. So doctrine of necessity is an argument you can put forward which is not there in law, yet because of survival you can put it forward. Therefore, in the Madhya Pradesh case, the argument was that if we do not allow governor to exercise discretion and give permission to prosecute of this governor, if in his prima facie opinion materials exist, the system of parliamentary democracy will collapse. Yeah, Dudley's case. Yeah. So that's the answer. Now, let me come back to my union territory case. In the case of the president and the governor, we saw that where aid and advice is given, the president or the governor is bound by it. In those areas where he is bound by the aid and advice, of course, where the governor acts on his discretion, there is no need for aid and advice. However, in the union territories, we notice an asymmetry here. And what the judgment tries to show us is why there is this asymmetry. If you take the case for Delhi, for example, Delhi was always a part of Punjab. In fact, till the early part, 100 years ago, the High Court for Delhi was the Punjab High Court. And the Punjab High Court was located where? It was located in Lahore. But once Delhi became the capital in 1911, 1911 is of course when the King George something, 4 or 5, one of those George, came to Delhi. And the great royal darbar was held, in Coronation Park. Those of you who are familiar with Delhi, it's near Mukherjee Nagar. That's where the king came, and that's where the darbar took place. And all those princes, and the princes came and gave their salam to the king. And you had, you would say the 9 big princes, the ones who got the 21 gun salute. They are the big 9 of India, and they were given land around India Gate, Jodhpur, Jaisalmer, Jaipur, Bikaner, Pataudi. No, Pataudi was a smaller one who was inside, but the big ones are all here. Dholpur, Baroda, that's right, all of them. And all the lesser ones who got smaller gun salutes, all of them were there. Hyderabad. Yeah, of course, Hyderabad was a big one. Yeah. So, where was I? So, 1911, capital shifted here, and therefore, land was taken away, the Tehsil of Mehrauli and Delhi was carved out of the Punjab and handed over to this new territory called Delhi. And you have what you will see in Delhi Laws Act, whereby the administrator of the Chief Commissioner of Delhi. So the administrator of Delhi was called the Chief Commissioner. The Chief Commissioner by this law of 1912. Let me just do a little bit of history, only because it's interesting, it's Delhi, and I like history, okay? So under the Delhi Laws Act of 1912 and 1915, that's right. And Akshay, as I was pointing out to you, the ones who had the biggest gun salute were given lands around India Gate. Okay, Hyderabad, Baroda, Bikaner, Jaisalmer, Jodhpur, all of them were around India Gate. And then slightly lesser kings were given one rung, so it was like a concentric circle. So the next one was Pataudi, all the smaller ones were there. Okay, Travancore, Pataudi, and all the second. And there were many ways in which the British exercised the hierarchy. One was the gun salute. So, Maharaja the Raja Padhar mein hai, you would have 21 gun salute. If you were a slightly lesser king, you had 15 gun salute. Okay. And the hierarchies were maintained in so many ways. If you were one of the big princess's sons, then your children went to HSM College in Lahore to study. But if you were one of the lesser kings, then your children, or an army general, then your children went to Doon School. Doon School was only number 2 in the hierarchy. So there were the various ways in which the hierarchies were reproduced. And it's interesting that how society creates these hierarchies and how it reinforces it through school, through salutes, through, it's quite amazing. Anyway, now the chief commissioners of provinces like Delhi all became Part C states when our constitution was adopted. Okay. So at the time of the formation of our constitution adoption, we had Part A, Part B, Part C states. And chief commissioner provinces like Delhi were a Part C state. But then the 7th constitutional amendment in 1956 had only 2 categories, states and union territories. Okay? And Delhi became a union territory. However, as I pointed out in my last class, by the 1963 Union Territories Act, all union territories were not equal. There were some that had a legislative body and some that didn't. So if you were to take, for example, Delhi as an example, okay, in 1956, when in 1963, we had a legislative assembly and a chief minister, okay? And in 1966, some form of a limited representative government happened in Delhi. We had a metropolitan council, okay? And then, of course, subsequently in 1991, we got a legislative assembly. So we had a chief minister. Now the question for us, the legal question for us is, what aid and advice does the Delhi Council of Ministers give? And is the LG bound by the advice? Now, last week, when we had a class and Abhishek and Abhinav were making their presentation, they pointed out to us that under the 1991 Government of NCTT Act and the TBR rules, that is Transaction of Business Rules, very important, is TBRs. Under 239, every union territory has an administrator, and this administrator is appointed by the president, which means he is bound not by the aid and advice of the president, but the decision of the president. Look at this word. He is bound by the decision of the president. However, under 239 AA, there will also be a legislative assembly and a council of ministers who shall aid and advise the LG, who is the administrator. How do we harmonize this? And what Justice Deepak Mishra, as well as Justice Chandrachud, as well as Justice Ashok Bhushan, in their three separate opinions, tell us that we must harmonize it. And the clearest is actually in Justice Chandrachud's judgment. He says why we must harmonize. He says we must harmonize because parliamentary form of democracy is the adopted form of our constitution. And this parliamentary form means that the ministers are collectively responsible to the assembly. And if they are collectively responsible, then they have to explain their decisions. If they have to explain their decisions, it stands to reason that those decisions that they take and which they convey to the LG will be construed as the aid and advice of the Council of Ministers. So over those areas over which they have executive power, which is the state list minus list 1, list 2 and list 18, they have executive power. Over those executive powers, they are on the principle of parliamentary democracy accountable to the Delhi Legislative Assembly. And this is a constitutional feature. And as Justice Chandrachud says, if we were to say that the LG is not bound by the aid and advice, then, and we say that the LG is only bound by the decision of the central government, then we are not giving due effect to the constitutional amendment which introduced 239 AA. Then in which case we are merely saying the union territory is run directly by the central government. Then why do you have a legislative assembly? Why do you have a chief minister? Therefore, we must harmonize. And how do we harmonize? In all those areas, barring 1, 2 and 18 of list 2, executive power of chief minister or council of ministers happens, they will be bound by the aid and advice. However, and this is the most important however, unlike the case of a governor or president, the proviso to 239 AA clause 4 tells us that on any matter, the lieutenant governor can seek the opinion and advice of refer the matter to the president, not for advice, I beg your pardon, for the decision of the president. And Justice Deepak Mishra says any matter cannot be every matter. It only means those matters where after due discussion has happened under the TBR, no resolution is forthcoming, only then can the LG refer the matter to the President. As a condition precedent, he is bound by the aid and advice, and if he wants to exercise a different opinion, first he must try to dialogue and settle the differences with the Council of Ministers, and only if this is not possible will such a reference to the President be available. What the court is actually saying is non-application of mine and unnecessary referral to the President will then become subject to judicial review. That is, the courts can well ask, why, before you referred it to the President, did you take all necessary steps as laid down in the 5-judge bench decision to resolve these disputes? And only after dialogue and discussion this dialogue and discussion becomes what we call a condition precedent to the reference by the LG to the President under the proviso. So the proviso is not given a broad meaning, it is given a narrow meaning, which takes me now to a related point. All the 3 judgments ask, how do we interpret the proviso? And they give you 2 alternatives. They say either we can adopt a literal interpretation or we adopt a purposive interpretation. Under a literal interpretation, any matter can be referred, can be literally, even if an aid and advice on this matter comes, you can say, nahi, main aapka nahi manta, I'm going to refer it to the President, which means central government will decide, because President means aid and advice of the central government. They say not any matter should not be interpreted as every matter. It must be only those where disputes or differences cannot be resolved, and only then. And we have to adopt not the literal interpretation, but a purposive interpretation. And how do I determine what is the purpose of the Constitution? You read it as a whole, understand from the basis of Keshavan and the Bharti judgment, what are its basic features, and if parliamentary democracy and if collective responsibility is a basic feature, which it is, then you must give some importance to the view of the Council of Ministers. If you reduce that to 0, then the court says, what is the point of Article 239AA? You might as well have a directly administered union territory finished. The fact that there is means that we have to give. And Justice Chandrachud, in his separate concurring decision, asks a question. He says, is the LG as a constitutional authority either bound by the Council of Ministers, aid and advice, or the decision of the President? Is there third area over which the LG exercises discretion? I'll repeat it. Under clause 3, there is a Council of Ministers at the state level which will aid and advise the LG. Okay. Other than 1, 2 and 18 of the state list, all other matters in the state list and concurrent list, you are bound by the aid and advice. With regard to 1, 2 and 18, the LG is bound by the advice coming from central government, which means through the President, aid and advice of the central government. Is there any area where he can exercise his own discretion? And the answer is no. Unlike the governor, unlike the President, who have some small, no doubt, undefined area, but where they can exercise their own discretion. The only discretion which the governor can exercise is if he has a dispute with the aid and advice given by the state government, and that dispute cannot be resolved, he has to refer it to the President. But there is no meaningful way in which he can decide to act on his own. Either he is bound by the aid and advice of the Delhi government, or he is bound by the aid and advice of the central government routed through the President. Therefore, while aid and advice is a word that comes everywhere, and wherever it comes, the person receiving that aid and advice is bound by it. Yet, what we have seen is The president can choose once not to be bound by the aid and advice of the Central Council of Ministers. Article 74 provides. But second time around, they reiterate the decision they've done. Governor has a small area of his own discretion where he is not bound by the aid and advice. But the LG is in a different category. He is bound by the aid and advice under 239AA3A, and in other matters, he has to take the reference and decision of the LG, and there he is bound. Now, is there an area where, what are those areas where he is bound by the president? And Justice Chandrachud in his decision talks about section 41 of the, which is the section 41. Section 41 of the GNTCD Act, where under any law or where he exercises, where a lieutenant governor exercises discretion under another law, not under the constitution, under another law, he can exercise discretion. Okay. And what are those areas of discretion? If you come to the 2019 Government of NCTD case versus Union of India, the court says appointment of public prosecutors. This falls under an area under section 41 where he can exercise his own discretion. But please note, this exercise of discretion is under a specific law, not under the constitution. Just like in the MP Special Police Establishment case, we noticed that in the Vaishno Devi, governor is the chief administrator. And in that capacity, he takes certain decisions. Where he is acting under his discretion under a specific law, he is not bound by the aid and advice. And the third example I gave, where the President of India is the visitor to Delhi University. And in that capacity, he appoints the Vice Chancellor. In this discretion, he is not bound by the aid and advice because he is performing a statutory duty. It's not a constitutional duty. So therefore, as students of constitutional law, we must be clear about that distinction. So section 41 of the GNCTD Act, which gives you an area of LG discretion under section 41, is a discretion conferred on him by a...
दोस्तों, अगर आपको आज का लेसन पसंद आया हो तो वीडियो को लाइक करें। इसी के साथ अगर आपने अभी तक हमारा चैनल सब्सक्राइब नहीं किया है तो सब्सक्राइब के बटन पर क्लिक करिए और बेल आइकन दबाना ना भूलें, ताकि आपको एजुकेशन से रिलेटेड नए नए अपडेट्स मिलते रहें। और अधिक जानकारी पाने के लिए आप हमारे फेसबुक और इंस्टाग्राम पेज से भी जुड़ सकते हैं, जिसका लिंक डिस्क्रिप्शन बॉक्स में दिया गया है। धन्यवाद।